topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Houston. Welcome to another Ask the Expert show, where for the last 17 years, we brought you the top experts in the field of legal, health, financial, and home improvement. Hey, we want to welcome our TikTok audience today. We went live on TikTok the first of this month. I am just blown away about the numbers of people who are watching and listening to the show. On top of our other 70 platforms, we have got a great show for the next 25 minutes. We have the top firm when it comes to community association law. If you don't understand what that means, it's HOA condo law. And we have got the top law firm that's going to educate you today with all of your questions. Let me welcome you to our attorney, Shannon Lang. Good afternoon, Shannon.
Hi, Steve. It's great to be back with you.
Hey, I got to tell you, people love your show. We're getting now messages from management companies that are watching, board members that are watching, and they love the way you explain the laws to them, basically, bottom line. You know, we do this all the time, Shannon, but I'm going to do it for our new TikTok audience. Tell people about your firm, Lang & Associates.
Sure, I appreciate it, Steve. We're a small law firm here in Houston. I started the firm about 10 years ago after leaving a kind of a big law. After law school, I clerked for a federal judge, worked in big international law firms on giant cases, but decided I wanted to do something where I'd have a little more contact with clients and be a little more involved in the community. Over time, we just developed this community association practice, and it's really grown. We have dozens, if not hundreds, of clients that we represent now. And, we really take pride in doing kind of what you said, explaining things to people so they understand what's going on, trying to counter the pretty negative view most people have of HOAs, and trying to, be cool and kind with people as they work through issues in their communities and in their homes. We're a small firm, and what we really also take pride in is we answer the phone. So when people want to get a hold of us, they can. They don't have to go through a phone tree. They're not going to be stuck with some virtual receptionist. They're going to talk to somebody in the office who's there to solve their problem.
Gosh, you read my mind, and we've gotten emails. And by the way, when you email us about the show, we always send you back all the contact information for Lang & Associates. But people have been complaining, I guess they have other firms that represent them, that it takes forever for them to get back with them. So I'm so glad you brought that up.
Yeah, we try hard. If you get our voicemail, it's because every other person in the firm is on the phone, and we will call you back right away. I do my best to get back to everyone as quickly as possible, which, is usually right away. But if we're in trial, if we're in court, it can be delayed. But I think that's important because we actually go to trial. We actually go to court. A lot of my competitors really are just debt collectors, but we maintain a litigation practice, and I'm in front of judges and juries all the time.
I don't understand how a community association cannot have a firm representing them. This is like running a big business, isn't it?
It really is. Even our small communities are managing other people's money, and there's a lot of traps for the unwary. This is particularly a problem for smaller communities that self-manage because there's just so much you don't know. But our big communities have multi-million-dollar budgets, and to manage that kind of money and the obligations that come with it and navigate the legal requirements for doing this the right way, it really does require a lawyer. We're busy. We don't go out of our way to create work. We have plenty that come to us. So I do understand the hesitancy people have in working with lawyers. I mean, look, I'm no huge fan of lawyers either. But there's lots of us out there, and it's important to talk to your lawyer, interview them, make sure you're on the same page with how you want the representation to proceed.
Well, I've got so many questions. I'm going to start off with, how much authority does an HOA actually have to refuse an ACC application?
Quite a bit. This is a question that we deal with pretty frequently. Most of these neighborhood communities are going to include in their governing documents a requirement that any improvements to anything you can see from the street generally is subject to approval by the board or by a committee called typically the Architectural Control Committee. Sometimes the governing documents post the guardrails on what the ACC can and can't do. And there's a few places in Texas law that place some limits on the HOA. But broadly, the board or the ACC have broad authority to make aesthetic decisions and to determine that something that's being proposed would be incompatible with the overall scheme of the community. We think about this when someone says, well, I want to paint my house pink. That's generally an easy one. No, that's not allowed. But where it comes up in other contexts is landscaping schemes, yard ornaments, flags, banners, and things like that, where one person's trash is another person's treasure. But the boards have these broader powers to say, no, this isn't the look we want for our community. They do have a lot of authority. And for folks who really want to be able to do whatever they want to do, what we always tell them is don't buy into deed restricted communities because you don't have the same freedom that you would have in a non-deed restricted.
I have got, someone just wrote, greatest question. I don't even think we've gotten a question like this before. A person who just moved to Houston and just moved into a association. They want to know, why are there so many rules and regulations when you're in an association?
Well, I will say not every association has a lot of rules and regulations. We tend to find that the bigger, more master plan communities will have more. And these all, for the most part, stem from the builder and the developer. The person who's come in and invested in creating this community has a lot of power to set the rules and regulations, and will typically do so in order to create their vision, their aesthetic vision for the community, and sell houses and units. Those rules are going to generally stick because the people who buy have the right to rely on those documents as a commitment as to what the community will and will not be allowed to do, how things can look. And that's subject to change, of course. There are ways to amend, but the idea in these communities is really for, mostly from these builders, to create a lifestyle that they can sell to buyers, an aesthetic vision that they can sell to people who are in the very competitive market for home buying.
So I'm seeing there's a lot of people, which I already knew this, there's a lot of people moving to Texas. Mm-hmm. And Texas has different laws than other states do. So when a person moves to Texas, they want to know if you're going to be doing a show on, and I think we've talked about this, on hurricanes, because hurricane season is right around the corner, and you do get hurricanes in Houston.
We sure do. And yeah, we are all gearing up right now for hurricane season. What that means in my office is we're making sure that all of our communities have the proper insurance. This is particularly true for condominiums, where the condominium association is responsible for roofs and siding and things like that. But yeah, I mean, hurricane is a really big deal here on the Gulf Coast, and people need to be prepared. Perhaps shockingly, what has been a bigger impact in recent years have been these freezes that we've experienced. A lot of people moving to the Gulf Coast are pretty used to hurricanes. We get them most years. Houston certainly floods, and I'm not sure we've done a great job of remediating that. But every year or every other year now, we're having these hard freezes, and those are really wreaking havoc on the community as well, in the broader area here. And so for HOA, it's really about insurance, and it's about messaging, preparing people, making sure that they have what they need to protect their homes. The HOA is generally not going to be responsible for flooding. Condos are a little different, but we still want to work with our owners, because an owner with a flooded house is an owner who's going to have a hard time meeting their other financial obligations. It's going to be a house that they may or may not be able to live in, and that may be in a state of disrepair for some period of time. So we think it's in the best interest of the community to be pretty forward thinking and get out ahead of these things as we see hurricanes coming through the Houston area. And we'll see what this season brings us.
Shannon, do you get very many calls about support animals?
Oh, we get lots of calls about animals. Yes. HOAs can limit the types of pets and non-pets that are permitted in the community. Most communities, except acreage lots, are very clear that they won't allow fowl, chickens, goats, things like that, farm animals. This is a battle we have a lot. People are really into chickens right now. And again, if you want chickens, we say don't live in a deed restricted community and live on a big lot. But the rules can even be applied to pets. And for a lot of communities, you'll see deed restrictions that limit the number of animals that are allowed in a home or a unit. They may even limit the types of animals. And for a condominium in particular, this can be important and enforceable because of the insurance obligations that these communities have. One thing we definitely see are people trying to avoid these rules by claiming that their animals are service animals. And I use the word claiming not to suggest that those aren't true. Many times it is true. Often it isn't. Particularly what we've seen recently is an influx of emotional support chickens. And, I'm certainly skeptical, but with the right documentation, the HOA should permit you to have your emotional support animal subject to certain limitations. For example, the emotional support chicken needs to be in the house, not in the coop, because, they're providing emotional support. But those are things you have to be very careful about. And another reason why we think associations definitely need good counsel, because navigating a claim that an animal is a legitimate service animal or an emotional support animal, or broader complaints that or concerns that a community isn't meeting their Fair Housing Act obligations, can really create a lot of liability for a community. And so those matters need to be handled pretty delicately.
For those of you who've just tuned in, we're talking with attorney Shannon Lang of the Lang & Associate Law Firm out of Houston, Texas. They do community association. For those of you who don't know what that is, if you live in an HOA or a condo and you're part of an association, we're talking about that today. So if you've got questions, please join us. Shannon, do you have, I'm here in Florida. Does Texas have 55 plus? We
do have 55 plus communities. Those are permitted and allowed, just like they are most of the country. I think we represent one right now. But yeah, those are great communities. They tend to have fewer issues than others. Often the biggest one is suddenly somebody has to raise their child or grandchild, and suddenly it's not 55 and up. But again, those are issues that are generally handled up.
Okay, because I know it's really big here in Florida, and there's a lot of regulations when it comes to 55 plus. I want to get talking about HOA again. Can an HOA actually enter a property without a person's permission?
This one we get a lot too. And unfortunately, the answer is it depends. For a lot of communities, the deed restrictions will include language that state that if an owner refuses to abate a violation, the association, after notice, has the right to enter and cure and then charge those costs back. So that is often the mechanism by which an HOA can get onto someone's lot Typically, it's to do forced mowing. Typically, those are investor-owned properties. So the landlord's absent, the landlord isn't mowing, nobody's answering the letters. The HOA has the right, if it's in their documents, to enter, mow, and charge that back. And a related one that's more common for condominiums is there's often a right to enter to abate an emergency. And where we see that happen is burst pipes. If you're in stacked units and your upstairs neighbor has burst a pipe and water's coming in and nobody can get in to get a hold of that neighbor, they're on vacation, what have you, there is a right to enter and abate. So there are rights, and that's not considered trespassing in the state of Texas. That being said, we tell all of our communities, our boards, to exercise real caution, because Texas, I think like Florida, is very much a stand your ground state, and we would hate to see anybody get hurt or shot or any of that because they've entered into someone's property. It's always done with notice.
Okay. Can HOA, can they actually prohibit you from renting your house out?
They can under certain circumstances, yeah. Again, it's more of an issue sometimes, typically with condos, but it is allowed under state law to have rent caps if that's written into your documents. So for example, a community might have a set of governing documents that says no more than 20% of the homes or units can be rented, and then they'll set up a system to determine who is entitled to be a landlord. The purpose of that is typically to maintain value in the community, because we do tend to see that the higher the number of investor-owned properties, the higher the number of tenants, we have maintenance issues. Those homes don't tend to be kept up as well. Tenants don't tend to take care of homes the way owners do. Another place where this is coming up a lot is in short-term rentals. And under Texas law, short-term rentals can absolutely be prohibited. In fact, even if you buy a unit or a house in a community thinking you can use it as a short-term rental, if the policies change or the rules change while you're living there, you don't get grandfathered in. You will be subject to those new rules, and those short-term rentals have to stop. We deal with this at least weekly, where folks are buying a unit, often condos, and putting it on Airbnb, and it's just wreaking havoc in these communities for the same reasons that, too many tenants wreak havoc. But with short-term tenants, they more often than not are there to have a party. There's a lot of people, there's a lot of noise and trash and disruption. And we've spent a good amount of time litigating short-term rental cases.
Here's another TikTok question. I'm new to our community. I've never been on a board before. Do you have to have certain requirements to serve on a board?
Typically, the only requirement is going to be that you're a member of the community, meaning that you are on the deed to the home, the lot, the unit in your community. That's usually the only requirement, and that's not even a requirement. From a more practical perspective, we always say that the only requirement is a desire to serve. You don't need a background in accounting or construction or law. An HOA has access to professional service providers who do all those things for a living. The hardest thing is finding members in the community who want to be on a board, who want to serve, who want to show up. I think a lot of that is because, one, they think it's going to be too time consuming, but with good service providers, it shouldn't be. We hear from some people that they feel like being on the board is being a narc. I don't feel like it's that at all. I'm on the board of my HOA, and it's really about allocating resources, exercising judgment, and trying to maintain good property values, which is something we think all owners are pretty on board with. So we always encourage people to run for the board. It's so hard to get people on these boards, and you do not need any specialized background.
Another TikTok, actually, two people asked the same question. They want to know about handicap parking. Is there a Texas law that states how many handicap parking spaces are needed? I'm trying to get more. Any suggestions?
Well, it depends on your community. A lot of subdivisions are on public roads. And then that's going to be dictated by the by the city or the county, whatever the jurisdiction is. Typically, there's no requirement for handicap parking outside of a home. There may be outside of an amenity like the clubhouse or the pool. For communities with private roads, there's really no requirement. And the same is often true of condos. So where this issue tends to come up is with the Fair Housing Act. If you're in a deed restricted community and you have a mobility or a similar impairment that requires you to have a certain parking space, typically thought of as a handicap spot, then you should present that to the board, and the board should, as long as it's established, should accommodate that to the extent that they can. We've worked with a condo that had to assign a parking space that was otherwise a visitor spot to an owner who claimed a mobility impairment, and so it could be done. In subdivisions, it's, most of the time you're going to have parking available right in front of your house. But if not, you just make a case to the board and establish that you've got this impairment. Importantly, establishing it doesn't mean turning over medical records or detailing medical complications. You just have to present the claim in a way that is not privacy infringing, but enough so that if it's not obvious, the board can conclude that there is an impairment that requires an accommodation.
We just make sure you tell us when your questions, if you're a condo or an HOA. We're getting several questions, Shannon, about Airbnb. Here's one that said, I bought my house and I wanted to use it for an Airbnb. It wants to know, can an HOA stop that?
Yep, absolutely. Check the deed restrictions. It's possible that it's already prohibited. You'll want to look at the declaration to see if there's a minimum lease term requirement, any rules or regulations, you might find it in there. And even if there's no restriction now, these documents can be amended. And if it's amended later to prohibit it, that is enforceable against you. I mean, really, it's so not worth the headache to Airbnb in a deed restricted community, because even if you're able to do it, you're almost certainly going to have a really close eye on your lot, because neighbors hate it. They really hate it. And unless you've got great tenants, and no Airbnb landlord always does, you're going to be getting a lot of deed restriction notices. And in communities that you can find that the cost of doing this doesn't make any sense.
Shannon, I got to tell you, we do shows all over the country, not just legal. We do health and we do financial, home improvement. And I am blown away how popular community association shows are. Like my Florida people have been with us for 15 years. Your show, the numbers are God, there's so many people that have questions about living in an association. And I cannot believe the popularity. First of all, I'm so glad we have you, because your information is so good. People are actually just thanking us for having a show like this. And Shannon's with us every month, but the popularity of community association is amazing.
Well, so many of us live in them, especially here in Texas. These private developments are really the primary way that housing is built here. And there's a lot of law around it. There's a lot of there's some regulation. But I think it's just part of the Texas ethos, this kind of, independent, where we'd rather be governed locally than by some faraway city councilor. And I think that's why you see so much of it here in Texas, and I think in Florida as well.
Well, your show goes by so fast. Shannon, tell people how they can reach your office.
Absolutely. You can call us anytime at 832-479-9400. We're on the internet at shannonlanglaw.com. And like I said, we take great pride in answering the phone. We're happy to talk to board members, community members. We can't always take your case, but we can refer you to someone you can if we're too busy. But we love to talk to folks, and we love to explain what we do and try to help them navigate the sometimes complicated and sometimes unpleasant world of HOA.
Shannon, as always, great job. We'll see you next month, and have a wonderful weekend. It's attorney Shannon Lang with Lang and Associates. Folks, I'm telling you, if you're a manager, if you are a board member, if you're looking for a new firm, give Lang & Associates a call. We have got nothing but great report on them. We're going to go to break. We will be right back.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.